to everybody. I'd like to call the meeting to order for Monday, February 14th, 2022. This is the Plan Commission and Commission for Citizen Involvement meeting. Iris, would you please call the roll?
Buchanan.
Here.
Heap.
Here.
Helen Leak is excused. Pape.
Here.
Phillips.
Here.
Rigby.
Here.
Stewart.
Here.
Thank you.
Thank you. We have a quorum. So I'm not sure if we have a council update tonight.
Very quickly.
Councilor Mans, welcome to the Plan Commission meeting.
Thank you.
If you'd like to give us a council update, thanks.
I would, and I'll make it very brief. And I will be I'm going to log off because it is Valentine's Day night and watch the meeting later. But basically, the big news is that we had our goal setting meeting. The Lake Oswego Review did a very good job of summarizing our meeting. The big takeaways out of it was there were a lot of new items that may or may not necessarily impact planning at some point. We discussed improving community messaging, even though that hit really high on our city polling. One of the things that we're going to be looking at is developing a plan for the urban forest, which will be, it'll be fun. I'm really excited about that one. This is not to do with our development code in any way, shape, or form. This is looking at the health and safety of the forest. And of course, Scott can correct me if I'm wrong on this, Director Siegel. The other area that is new and that we are going to be looking at is a lot around sustainability. As you probably are aware, we've had a lot of discussion, people coming to, I don't know if you've had it at Citizen Involvement over time, wanting to talk about various sustainability issues that impact our city, such as, for example, leaf blowers, tree removal, that sort of thing. As I say, we're not doing anything on the development code with regards to trees, so that will not impact any work that you're doing. And some of this may not impact you at all. Just to wrap up, we're carrying over the business model for a sustainable fire department, 21st century fire department. We're supporting our Diversity, Equity, and Inclusions Board's work, adopting a funding strategy for pedestrian capital projects that will be, of course, pathways, trails, bike paths, as well as delivering all of our capital projects that we're working on, including wastewater, which I suppose could end up somehow involved with planning. There was a lot of discussion around foothills at the 100,000 foot level. So I don't know what will happen with that over the short run, but just so that you're aware. It was a very, very productive meeting, good, robust discussion. I'll send a link out to the Lake Oswego Review article because we don't even have the finalized version yet. And I think it's pretty concise, actually. So there you have it, everyone. Are there any questions for me?
Commissioners, any questions for Councilor Mans? Maybe one question, Councilor Mans.
Yes.
It seems pretty emphatic that we wanted to say that the forest code that you're mentioning is not going to be part of the development code. In the past, we've heard discussion that there was at least some in the city that favored that coming into the development code.
Right.
Was there any debate or discussion on that at the council meeting, and or maybe a little background, or was just kind of, you know, decided beforehand that it would be kept outside our development code?
There was discussion. I think it was because that is a large project and things could evolve. I don't want to speak without having reviewed what exactly was said by each of the commissioners. So excuse me, I don't have that. It was a all-day meeting, and I'll be honest with you, I don't remember exactly what was said. I know I was emphatic in saying that I would love to move forward on the urban forestry plan and looking at our, and this is going to sound terrible, but our assets as far as parks are concerned, our tree assets, our right-of-way, trees and right-of-way, and that type of thing that we have control over. I think the consensus, and again, don't quote me on this, I'll have more information at the next meeting around that, because that would, of course, be a big thing, is that it was brought up. And there was debate because there were commissioners, or I'm sorry, yeah, the counselors, thank you, who felt that that should not be taken on at this point in time. To that point, it was also, I believe, the staff's bandwidth was discussed and how much we do have in the pipeline coming through, both from our boards and commissions standpoint, as well as, like I say, staff work and council work. We have a total of, I believe it ended up being 19 goals to fulfill in the next really 18 months, because some of these things are carryover and will be carried over again. So stay tuned is about the best I can say, but it's not happening this year. And we do understand that the community members of the community are desirous of looking at that. I just don't think we're quite there yet.
All right, thank you. Commissioners, any other questions for Councilor Mans? I see none. Well, thank you, Councilor Mans, for your update.
Thank you. Thank you very much. As I say, I'll watch this and be prepared for next time, and happy Valentine's Day, everyone. Bye-bye.
Happy Valentine's Day. Bye.
Thank you. Bye.
Next on our agenda is a public comment. This is regarding issues not on the agenda. I'm not aware of anybody that wishes to make public comment tonight. Can you confirm that, Iris? Do we have anybody that wishes to make a public comment?
That's correct. We have no one signed up.
Thank you. Commission for Citizen Involvement, general updates. I don't have any updates for citizen involvement, so we'll move on to the minutes. The first minutes are December 14th, 2021. Iris, and just before we go into the minutes for December 14th, 2021, I believe we'll be deferring the minutes of January 10th, 2022 to a future meeting. Is that correct?
That's correct.
All right. So, commissioners, any comments on the minutes from December 14th, 2021? I don't see any. Would a commissioner like to make a motion to approve the minutes for December 14th, 2021?
Motion to approve.
Is there a second?
Second.
A motion to approve the minutes for December 14th, 2021. All those in favor, say aye.
Aye.
Any opposed? None?
I would like to abstain. I reviewed the minutes. I don't see a problem with them, but I was not present during the meeting.
All right. So any other abstentions? There's only one. Commissioner Phillips would like to abstain. Therefore, the minutes are approved. Thank you. So we'll move on to our next agenda item, item number 7. This is findings, conclusions, and order. This is item 7.1 on our agenda, the 2021 Annual Community Development Code Amendments, LU 21-0057. Public comments are not accepted tonight. On January 24th, 2022, the Plan Commission made a preliminary recommendation that the City Council approve the proposed amendments. They also recommended that the proposed amendments to LOC 50.04.003.7.b, which would reduce the maximum size of the boathouses within the Lake Oswego setback, from 570 square feet to 500 square feet be removed from consideration, keeping existing code. The staff coordinator is Evan Fransted, senior planner. Would staff like to give any update?
Chair Heap, this is Scott Siegel. There's no update other than to say that the draft findings were to reflect the commission's tentative decision, and we recommend approval.
Thank you, Director Siegel. One point of clarification on the maximum size of the boathouses within the Oswego Lake setback from 560 square feet to 500. So just to make sure we're all on the same page, this was removed. The recommendation was to remove that, and so in our findings, conclusions, and order, this has that change in the Oswego Lake setbacks removed, just so all the commissioners are on the same page. Is it correct understanding, Director Siegel?
That's correct.
Right. Commissioners, any discussion on the findings and conclusion or in order? Any other questions? Oh. Is there a motion then to approve the findings, conclusions, and order for LU 21-0057? This is the proposed amendments to the Community Development Code.
I'd like to make a motion to approve.
I believe that was Commissioner Buchanan made a motion to approve. Is there a second?
I'll second.
Commissioner Stewart seconds. Iris, would you please call the roll?
Buchanan,
Here.
Yes or no?
Oh, excuse me. Yes.
Heath,
No, based on the fact that we removed the changes to the Oswego Lake setback.
Roger.
Pepe,
Yes.
Phillips,
Yes.
Rigby,
No.
Stewart,
Yes.
Thank you. The motion is approved. Next, we'd like to move on to item number 8 on our agenda. This is a work session. 8.1, the House Bill 2001, work session number 4, PP 19-0008. Public comments are accepted. However, I'm unaware of anybody that would like to make a public comment tonight. The Commission will review and provide input to staff on proposed development review process for middle housing and other remaining issues prior to developing a public review draft of code amendments required for compliance with state middle housing requirements. The staff coordinator is Eric Olson, senior planner.
All right, thank you, Chair Heap. I'm waiting for the slides to get pulled up here. And I will just mention, joining me today is Ellen Davis from the Planning Department, so she'll be helping out with one component of this presentation. But yeah, I'll just get started here. This is the fourth and final, it's kind of scary to think about, but the final work session for House Bill 2001 at the Planning Commission today. So after today, we'll be moving forward to a public hearing in April. So there'll be a public review draft, but that will be the next step. And today, we're really trying to focus on some of the implications for the changes to the development review processes that will be required and that we're recommending for compliance with House Bill 2001. So as I mentioned before, we'll have Ellen Davis, who's a planner with the City of Lake Oswego Planning Department. She is more of a specialist in development review than myself, so she has a pretty good understanding of our existing development review processes. And she'll go ahead and give you an overview of those. And I will then pick it up and talk a little bit about what we're proposing to change for middle housing. I'll also talk a little bit more about some of the mitigation and public improvements standards that we're proposing to accompany middle housing, as well as the Senate Bill 458 requirements to allow expedited review of land divisions for middle housing. So that's going to cover the process a bit as well, but also just kind of mentioning that because we haven't had too much of a time to discuss that with the Planning Commission. So with that, I'm actually going to hand it over to Ellen to get started on her portion of the presentation here, just talking about some of our existing processes. And I will just say, I really appreciate Ellen joining us tonight. I know it's Valentine's Day, so we appreciate her dedicating her time. And yeah, just as another staff, thank you, Ellen. So.
Eric, and good evening, commissioners. I'm going to be discussing the difference between ministerial and minor development, and that's talking about our current process, not the proposed processes that Eric's going to talk about. So currently, our land use decisions you can think about on a continuum between ministerial development, and those are going to be the simplest and quickest. Got minor development, and I'm actually not really going to talk about the major development at all because that doesn't relate to housing. Major development are more commercial projects and phased projects and things that don't really apply to middle housing. So we're just focusing on the ministerial development and the minor development processes. So what does ministerial development look like? Currently, right now, building permits for single-family residential development or duplexes would be a ministerial process. You just apply for a building permit and move forward with your renovation on your existing house. Lot line adjustments for small adjustments between neighboring properties that don't increase the potential density of either property. So just small adjustments and accessory dwelling units are all going to be currently ministerial. Right now, minor development is variances. If your addition isn't going to meet one of the standards, like a setback standard, you can apply for a variance for relief from that standard, but that's going to go through a different process. You don't just apply for a building permit. You've got a bit more that you have to jump through. Multifamily development, such as 3 or greater dwelling unit complexes, those can be townhouses, apartments, or condos, would go through a minor development process. Partitions to divide property into 2 or 3 units of land, and also subdivisions, so land divisions of greater than 3 units of land. So the ministerial process is relatively straightforward regulations. Staff reviews the proposal for compliance, so we can look at the building permit plan or the ADU development and make sure that that proposal is meeting all of the requirements for the zone in which it is located. And staff make sure that that meets all of the development guidelines. And once it does, we issue the permit. There is no opportunity for public notice. There's no comment period, and there is no appeal opportunity, no public hearings on ministerial development whatsoever. If you disagree with a staff decision, you don't get to take it to the Development Review Commission. It doesn't go there. Minor development, on the other hand, the very first step is a pre-application conference that's required in pretty much all minor development processes. Notice is provided to all property owners within 300 feet. We also send that notice out to the neighborhood association, and a notice sign gets posted in front of the property. And there is an opportunity for public hearing. So some minor development, like subdivisions or major variances, go straight to the Development Review Commission. The staff just makes a recommendation. We don't make a decision. The hearing body makes the decision. But other development, like minor variances or partitions, those would be a staff level decision that can then be appealed to the Development Review Commission. If the applicant or a neighbor or neighborhood association, anybody disagrees with the staff decision, then that goes to the Development Review Commission, or that decision can be appealed to the City Council. So the decision makers and the steps involved, and especially the difference between no public notice, no public comment, lots of public involvement at the pre-application stage. Sometimes neighborhood meetings are required depending on the level of minor development and the opportunity for public hearings. So the differences are really the public involvement and the decision maker. So that was a very brief overview. Are there any questions at all?
Ellen, this is Scott. And I just add that the reason that ministerial is ministerial and not minor is that the standards, although there are clear and objective standards for minor development, ministerial literally is a checkbox. I mean, not literally, but it is so clear and objective that it's really a yes or no answer as to whether or not the standard's met.
That is correct. So those are building permits reviewed does the new duplex meet all of the setbacks? Is it meeting the maximum lot coverage, the maximum percentage of the lot that can be covered? Yes or no? Those are very straightforward answers. Whereas the minor variance process, if you can't meet those setbacks, there are more discretionary criteria looking at your proposal and whether or not that would have impacts on the surrounding neighborhood. And it becomes a more discretionary level of review in the minor development process. Thank you.
Great. So if there are no questions about just our typical processes, and obviously we'll, if you do have a question for Ellen, I would encourage you to ask her now, because you might have other questions pop up, but I think we'll dismiss Ellen for the evening. So if there are any other questions for her, we should address them now. And if not, I will keep going. All right, thank you so much, Ellen, again. So now I'm going to talk a little bit more about what we're proposing to change to go along with middle housing requirements. So essentially what we're looking at here is a requirement from the state under Division 46 that middle housing must be treated the same as single family housing. So when we discussed this back in I believe it was both at a Planning Commission and City Council joint meeting in November, as well as our first work session in December, we got some, at least initial sign off on concepts to classify triplexes, quadplexes, townhouses, cottage clusters, and duplexes are already classified as ministerial development, but we would classify all the other types of middle housing as ministerial, as would be required by the state. So I just really wanted to think through a little bit of what that means in terms of processes. So, Ellen was sort of pointing out the differences between ministerial and minor developments. There are some differences, and essentially what we're proposing is to apply our ministerial process to applications that would be considered minor today. So triplexes, quadplexes, and cottage cluster developments would not have pre-application conferences, neighborhood meetings, public notice requirement, or a public hearing, because that's how we would process a single family housing application. When it comes to townhouse development, it's a bit more complex. There are other, essentially because the definition of a townhouse would be an individual unit on its own lot. They do require a land division for a townhouse development. So the land division component would be considered minor development, but there would be no design review for design standards that would be required today for something like a multifamily development, which is kind of what these would be categorized as right now. So I just wanted to kind of point out some of those implications that this will have a little bit different of a process than what we are used to today. If there's any direction really on these recommendations, more clarifications than anything, but if you have any questions, we'll be jumping into mitigation in just a second. So I guess I'll stop here and just address any questions if there are any. All right, I am not sure how to tell if there are questions, but it looks like there might be one.
Vice Chair Pepe, would you like to ask a question?
Yeah, so Eric, right now we're at the crossroads of moving forward with what we had originally identified as what you just went through from the Planning Commission's direction, and possibly a little window of opportunity to adjust that. Am I understanding this right?
I would say there isn't much space for adjustment, to be honest. I think more just wanted to clarify that what the differences in the processes are for the Planning Commission. And, if there's any other input that you have, if there's any sort of modification to your previous direction, it'd be good to know. But I'm not sure how much we could adjust it, but I'm, open to direction, of course.
Okay, thank you.
I think, just to move a little bit forward on those questions, the one other move that could be made would be to subject single family housing to a, minor development process, which would, entail a very significant shift in the way that, all building permits are reviewed essentially at the city. So we've received direction that that is not a feasible path forward, and that would have a dampening effect on construction in general. Yeah, and I don't know if I'm allowed to call on the commissioners, but Commissioner Phillips, it looks like you had a question
Oh,
too.
sorry. Yeah, I couldn't see. Commissioner Phillips, if you'd like to ask your question.
Yes, I'm just a tad confused, I believe. What does land division mean? I read it this afternoon, and the way I read it, and I thought I understood it, was if you have a townhouse before the HB 2001, that meant, single ownership. Is that what we're talking about here? You got to be able to divide the land for the townhomes. Have I got that part correct?
So when it comes to Senate Bill 458 land divisions, that is accurate, but we do have other land division processes that we would use at the city. So regardless of how you do it, there could be, as Ellen was explaining, partitions or subdivisions where you have a larger lot and you subdivide it into, multiples, three, let's say, one lot into three different lots. So there would be, that process will still be available, but there are other processes that I'll talk about a little bit later in the presentation that I haven't really referenced yet that are specific to middle housing.
Okay, so that part I understand now, but so now that 2001, HB 2001 is on the books, if you build townhomes now, you don't have to go through the more rigorous procedures? Is that that a townhome would have had before?
So
reading that correctly?
So again, there's sort of two components of the townhouse development. So currently there would be that partition or subdivision rather, that is almost required by definition. Each townhouse unit has to be on its own lot. So that would necessitate a minor development review. Today, in addition to that review, we also require that multifamily developments and townhouses of 3 or more units would go into that category. That multifamily developments go through what we call design review. So they need to make sure that they're subject to discretionary design standards that are set up to ensure quality design of multifamily structures, essentially. So the change that we would be proposing, and that essentially we're no longer allowed, and I guess to paraphrase the state regulations, we're no longer allowed to subject townhouses to additional review that we wouldn't require for single family. So we are no longer allowed to do the design review land use approval, but we would review similar standards at the building permit stage.
Eric, can I just append or add on to what you were saying? So really on design review in some parts of the country, that means that it's a very subjective evaluation of aesthetics. Here we don't have that, because under state law, our design review of housing has to be based on clear and objective standards. So I know you said a discretionary review, and there is some judgment involved in whether architectural elements meet our clear and objective housing standards, but they really are intended to be prescriptive and really clear and objective. There is one area where, and Eric will be talking about this in a moment, where we would need to switch over to, we would need to change our ministerial process in order to apply requirements or impose requirements on middle housing that we're not able to apply to single-family housing.
Currently,
so there's one area of discretion I think that we're going to be talking about, but I just wanted to clarify that, because we don't have a discretionary or subjective design review process in Oregon. It's based on clear and objective standards for housing.
Right, I guess I'm just comparing, so it's more about process, so minor development process for a design review as opposed to a building permit review of the design standards. So again, it would be 2 land use actions essentially today, a subdivision and that design review, and the design review will no longer be required under the changes.
Okay, thanks for the clarification.
And, you know, a lot of this process stuff gets very in the weeds, gets very technical. So don't hesitate to ask questions. And I know that this is stuff that's, you know, folks in the development review component of the planning department deal with quite a lot. I'm not sure the planning department deals with these sort of review procedure classifications as much. So feel free to ask questions if you need. You know, as we were implying a moment ago, as Scott mentioned, one of the biggest implications of classifying things as minor or ministerial and sort of different types of development is that it impacts the ways that the city can require public improvements or other mitigation for the impacts of a proposed development. So when a land use application comes in for a minor development, let's say, you know, I could use an example of a minor development, but let's use the subdivision sort of example at least. We have what's called conditioning authority as a city when it comes to minor development decisions to require public improvements, street frontage improvements, other things to mitigate the impacts of the additional lots and the additional density on the site. When we do a ministerial development review, though, we, you know, for a single family or duplex currently, we would not currently have that ability under our code. So currently, for ministerial decisions, you know, there's no opportunity for us to require what we would call mitigations or offsetting of public improvements. But of course, there are other sort of standard procedures that could still continue to be used. You know, there's obviously all development, whether ministerial, minor, or major, is subject to systems development charges and other fees that are designed to recompense for the development. You know, so just kind of to compensate the city infrastructure for the impacts of the development itself. But in addition to the SDCs and other fees that we could impose upon a building permit, with a land use approval, a minor development land use approval, we do have this additional conditioning authority that can help the city mitigate the impacts of the development. So in order to sort of address this, we're essentially recommending that we develop new, clear, and objective mitigation requirements that would be applied to ministerial development. So this would be a relatively new concept where we would take an opportunity for all building permit applications to look at clear and objective standards and determine mitigations on a clear and objective basis. Currently, we use sort of a Nolan-Dolan analysis. That's the land use precedent case to determine sort of a rough proportionality of mitigation to you know, accommodate a development on a case-by-case basis. So that's, again, kind of what we do for minor development. So we're going to be applying a different, less, you know, I guess a little bit more clear and objective, much more clear and objective standard to mitigation for ministerial, and this will be the first time we've really done this for single-family dwellings. So this would be the major impact to single-family development applications. You know, these will be relatively prescriptive. You know, we would want to give developers a clear sense of what they could expect in terms of what, you know, different types of developments would require for mitigation. And, you know, I think that would be, you know, one potential benefit of this. We would also try to take into account previous mitigation measures that may have been implemented at a property that could, you know, be used sort of as a credit, if you will, towards these clear and objective mitigation standards. So as I was alluding to a moment ago, you know, this would really, the idea is to make this a little bit more dialed in and, you know, if you will, right size the proposed level of mitigation to the development that's occurring and use a more standard process. Again, this would be better for developers because they would have a little bit more of a sense of what the city might require of them for the development they're proposing. And it could be a little bit more, could offer more certainty for the public as well. There is, you know, as we were pointing out, there are fewer opportunities with ministerial applications for the public to make comment or to appeal the decision. So at least if we're able to say you can expect, you know, for a triplex to see, you know, X, X, and X, then they, you know, might have a little bit more certainty and less concern about those applications going through. So I just want to mention that this is consistent with previous direction that we've received both from commissioners and from the city council to not pursue what is referred to as an infrastructure-based time extension request. So as a reminder, just a quick reminder, this is something we talked about quite a while ago, the IBTR, if you will, the request to extend the time that we have to comply with House Bill 2001 based on infrastructure would have really only allowed the city to delay the implementation of middle housing. It wouldn't really have, it would have sort of had a lot of negative effects in making the city sort of agree to, basically agree to provide infrastructure in a bunch of places where, we may not need it, more or less. So we felt that it would have been a little bit too much for us to go along and sort of agree to what the state needed us to agree to for that process. So anyway, this is also consistent with some input that we got from the city engineer back in April. We had a meeting back in April of 2021, we had a meeting with the city engineer, Erica Rooney, and she sort of concurred with this analysis that applications for middle housing should be handled more on an application by application basis as opposed to looking at citywide infrastructure more broadly and sort of trying to retool the city's infrastructure systems to accommodate 4 times the density, which would be quite a big undertaking. So, essentially we've had direction to move forward on direction that we got from DLCD, sort of an interpretation of this, that while cities aren't able to say, you cannot build middle housing here because we don't think there's enough infrastructure in this area, cities are able to say, you can only build middle housing here if you can provide the infrastructure. There needs to be an opportunity for the developer to provide the infrastructure necessary to serve their development. So this is one way we can kind of get to that requirement. We'd also make sort of an alternative path available for applicants that might not like the clear and objective mitigation. They might want to go through a more discretionary process. So we would want to have sort of a alternative path to this mitigation available through a variance. So that would be a minor development if the applicant so chose. So that is the end of that section, and I would like to pause for questions. Again, there's a lot of information to go over and a lot of different concepts that we don't talk about as much. So I'm happy to take any questions.
Well, yeah, Eric, one question. If we go back to the process and what you're outlining, there's currently in the minor development reviews, there's conditions of approval. There aren't conditions of approval in the ministerial process, but I believe what staff is outlining here is basically to create mitigation requirements that go along with the ministerial process. So how is that different than conditions of approval with the minor development process? And why don't we call the options the same, conditions of approval? Why do we distinguish the two?
I think I think maybe this is an Evan Boone question actually, but we do have conditioning authority to that we can apply to more ministerial building permit type applications. We just kind of choose to apply it differently today. I'm not sure if it's if it's really important whether we call it clear or whether we call it conditioning authority or mitigation, but it's a similar concept. Essentially, the idea is that we would apply conditioning authority in a sort of maybe more legally defined pathway. We would apply a conditioning authority to ministerial in a clear and objective sense. So I think that's probably the biggest difference is that under minor development processes currently, it is that sort of Nolan-Dolan rough proportionality analysis, and it is not clear and objective necessarily. So the idea would be to make it more clear and objective. And Evan, I don't know if I've characterized this correctly.
That's all correct, and I can just phrase it in a different construct, and perhaps that also communicates it. You start with your question was, is it conditions of, why can't we attach conditions of approval to a ministerial permit? I guess I should start there.
Correct. And I'd also add in the kind of goal of having easy understandable code, that maybe isn't ambiguous or misunderstood by the residents of the city? Why do we have different names for, seems to be very similar things, conditions of approval and now mitigation risk?
Yeah, well, the ministerial uses prescriptive standards and criteria, okay? And it's to check the box, as Director Siegel indicated. You start off with a checklist and you work your way down through it. The difference in a minor development, particularly when we're looking at the conditioning authority, that has sort of grown up under the Nolan-Dolan analysis, where it said that it has to be reasonably related to roughly proportional. But that doesn't meet, while that might meet the constitutional provisions, the U.S. constitutional provisions, it doesn't meet Oregon's requirements for housing when it requires clear and objective standards. So I think we have to move to that clear and objective standards for mitigation requirements, regardless of whether it's middle housing or not. But the reason we proposed it as part of this package is when land divisions have occurred, the assumption was they occurred on that a single family dwelling would come in. Okay? So the exaction was made, the mitigation was made on that assumption. So in order to have the same process apply, that would apply to single family dwellings and to middle housing, you can't have just a vague standard, because you can't measure whether or not it's the same standard that would apply to middle housing as would apply to single family, because it is vague under the conditioning authority language. So by going to a clear and objective standard, you want to get all your standards up. I mean, why not? You want to get your standards up front so everybody can see what they are, and the developer knows, and the reviewer knows we check the box and down, and this is what you're required to provide. If an applicant says, I'm providing X, Y, and Z, fine, they've met the standards. If they don't, then we deny the standards. In order to implement those requirements, the applicant would be posting the same sort of guarantees and performance bonds to provide those mitigations before the required permits would be granted, or before the sign-offs, the certificates of occupancy, et cetera, would be issued. So I would agree with Mr. Olson that it is somewhat a difference. Conditioning authority is kind of the same thing as a standard that is met, okay? But the difference, the qualitative difference is, if you know what the standard is up ahead of time, then you can review that as a checkbox ministerial. If you're looking at what we call the minor development process right now, and that's why it only applies to minor development and major development, it's squishy as to what is reasonably related to the impacts from the development. So as I said, I think we're subject to some challenge. For housing purposes, we need to have clear and objective standards anyway. That's all.
And for staff, I guess, bandwidth purposes, it would be difficult to make discretionary decisions for every single building permit. But, yeah.
Well, you couldn't do it uniformly, so you'd be challenged.
Right.
Yeah. So I've got a comment and then a question. So from what I'm hearing, what it sounds like is the difference between, so a ministerial mitigation requirement or standard like you're proposing is something that's clear and objective, whereas a condition of approval for a minor development is more customized to the application, and staff actually writes those, correct?
That's accurate, yes.
Yeah,
Okay.
and so I think maybe more to Evan Boone's point.
So they are different then.
Yeah, well, you will see conditions of approval on some minor development applications that the condition is change this dormer or change, this dimension on the building to comply with the standards. So it's not that the condition is, that there's some subjectivity involved. It's more about how the design, as it was submitted, perhaps didn't comply with the standard.
Right. But it's
So
more of a reaction to the application.
It's reaction, and
as opposed
Evan's
to
saying,
going through a list.
Yeah, it's reaction.
So then my question then is when you're talking in here about these clear and objective mitigation standards that you're proposing, and then in the staff report it mentions at a scale that is more right-sized to the level of development, could you give us an example of sort of what you mean by that? Like, what would be an example of something that would be right-sized to a development?
Well, I think it would be something that would be, well, I guess Evan has more,
Well,
I guess, experience with
I
the
mean,
conditions that we could be
Right.
doing. here, but-
The example would be, if you approve a lot, again, the base assumption with that single family, if you approve a lot that has a statutory right to go to duplex, do you require mitigations for duplex or single family? When somebody comes forward with a building permit application that wants a duplex, well, then you require the additional mitigation impacts, additional sidewalk, street improvements, et cetera, that would come from that statutory right, that outright permitted use to go from single family to duplex. You don't want to necessarily require every lot to meet duplex, triplex, quadplex standards, because otherwise then you'd end up with neighborhoods that might have 80-foot wide streets, et cetera, in anticipation of the maximum potential development. So that's not what the neighborhoods want, that's not and that I think might even conflict a little bit with the Nolan Dolan, because that's not related to the level of development. So that's a little bit of a challenge, but it probably would survive because they look to what's the maximum development potential. But we don't expect every lot to develop to the maximum potential. So you end up with infrastructure that is in excess of what you would want and what development would.
So what it sounds like you're saying is you're going to need to develop, if we go down this route, you would need to develop mitigation standards that are sort of, that fit each type of middle housing.
But I think the example would be, and I'll yield to the planning, but what do you require for single family? Well, you require a 5-foot sidewalk and some improvements on the stormwater, a little bit on the side, and you don't require street lighting unless you're at the corner. That's what. Now, if you're going to have a triplex, you might have a wider sidewalk. You might have more improvements to the roadway because you got dealing with more traffic in general. You need to deal with more pedestrian. How is that when you put in this pathway? Type of thing. So, as development would increase, as the intensity of development on a lot would increase, then the developer on that lot would have to provide more mitigations for that increased intensity. But as Mr. Olson indicated, what you would do is like a credit, you'd say, well, you've already got 5 feet of sidewalk, you have to provide, let's say 8, so you just have to provide the 3 more than you already have. Okay? But if you haven't provided 8 at all, well, I'm sorry, you don't get a credit because you didn't provide it. Sort of thing. So this would also be applied in vacant lots, in current single-family vacant lots, which were approved for purposes of development where there was a single-family development indicated, but and the mitigations would have been taken at that time, so they would be increased for that higher level of intensity.
And we still have to meet the constitutional tests on this too. So the mitigation requirements have to be calibrated based on the impact of a single-family dwelling or a duplex or a quadplex. So it may be that the lowest level of mitigation that's required is dedicating right-of-way to meet the ultimate right-of-way width or your side of the center line as what's required under the transportation plan. That would be absolute minimum. And then, it can go up from there based on impacts. But we need to look at that with the city engineer and Evan and the city attorney as well. So.
You establish legislatively what you now do quasi-judicially, okay, as to what are the levels of impact from the intensity of development. And you say, okay, this is the formula, thus we apply it, credit for those that have already provided mitigation, and then as Mr. Olson indicated, if a developer thinks the mitigation requirement doesn't meet Nolan, well, we can go ahead with the alternative analysis. It's not necessarily a variance, but I think it would be similar process. It's an alternative to the prescriptive standard.
Another question to staff, does this then mean that we can outright say that under this proposal it's permitted use?
Certainly. I mean, there are, yes, ADUs, duplexes under the statute are going to be outright permitted uses.
Okay.
Also, will all middle housing, yeah.
Yeah, all, yeah,
Thank you. Commissioners, any other questions? We don't see any.
All right, I can move forward then. Obviously there's a lot of, again, this is a very technical conversation. What is the right sewer line size for a triplex? That type of discussion. This is something that we're gonna have to work on with engineering to really nail down. But, we think that this is the best path forward, at least to getting to a place where we can mitigate for these more dense developments without making single family developments go through a much longer and different process than we do currently. All right, and so now I'm going to finish with the discussion of the expedited review of land divisions and Senate Bill 458. So, I think we had mentioned this again at the Planning Commission City Council joint meeting in November, but I just wanted to touch on this at a Planning Commission work session formally. Senate Bill 458 was adopted last year, in May of last year. It applies basically to any city or county that's subject to House Bill 2001. And essentially what it requires is the city to allow expedited land divisions for all middle housing types in order for lots for each dwelling unit to be owned and sold individually. So to basically facilitate the individual sale of middle housing units. So, essentially the scenario would be that, if you will, a parent lot, the lot meeting the minimum lot size requirements right now, would have to comply with applicable middle housing regulations. So you think about the dimensional standards, the sort of setbacks, the different lot coverage, floor area, all those things would have to be met on that parent lot site. Obviously, they'd have to comply with building code as well, firewalls and things like that. There would have to be separate utilities for each resulting lot, and you'd be able to require easements for shared utilities, common areas, parking, and driveways. But, you can't basically result in any more than one dwelling unit per each resulting lot or parcel. So it's a bit different than some of the processes that we use currently. Again, it's really supposed to be addressing some of the difficulty of making middle housing units easy to be bought and sold right now. There are barriers for certain types of ownership models like condominiums that do have additional costs that can be associated with insurance or maintenance that can be, again, a barrier, sort of a large upfront cost that can make it difficult for condominiums to form at a certain scale, especially a lower scale for middle housing. So it's supposed to essentially be making that easier for developers to be able to buy and sell these units. The city, isn't really able to, basically require more than we could require under House Bill 2001. So after the lot is divided, we wouldn't be able to then say, oh, well, these tiny, child lots, if you will, the smaller non-parent lots could not each be required to have driveway access, street frontage, or parking on the lot. They would have to, go back to that parent lot configuration and where the parking was located on that site, and the easements would have to sort of reference that. So the city can, though, require street frontage improvements that we wouldn't require for single-family detached, and we can, of course, prohibit the further division of those resulting lots or parcels after a middle housing land division. So again, I had mentioned, this is different than some of our other land division or partition subdivision processes. Basically, your typical partition and subdivision involves an increase in the density that you could construct on a given site. As Ellen mentioned, partitions are for creating three or fewer parcels, and subdivisions are for more than 3. And those sort of involve, again, this parent lot that's divided into new legal lots or child lots that have full development rights. So that's the major distinction, is that the full development rights would not translate for Senate Bill 458. So this would not necessitate an increase in density, because that is underlying in the zone. So because under House Bill 2001, we're essentially, in a general sense, allowing 4 times the density that we would today, you don't need to do a land division to access that additional density. So it's not required. These land divisions aren't required to be able to build more units on a lot. So it would only really allow for the creation of new lots within this sort of parent lot, but they wouldn't have the sort of child lots, if you will, would not have development rights. They would be sort of these middle housing lots, if you will, that would sort of exist within a different framework. They'd have, you know, as I was referring to on the slide before, you couldn't further divide them. There would be lots of, you know, easements, I guess, associated with them and other conditions and requirements that would go along with them. So again, you couldn't necessarily take the, you know, an existing lot that meets the minimum lot size requirements and divide it into 4 lots and then have each of those have their own, you know, 4 times the density. It wouldn't sort of, you couldn't continue to subdivide and subdivide. You'd have to sort of set it in stone based on that parent lot configuration, more or less. And, you know, another really important component of this is that these middle housing land divisions under Senate Bill 458 would be processed under an existing process that has existed since 1995, actually, at the state level. It's defined in the Oregon administrative rules, and it's the expedited land division procedure. It's, again, something that's existed for a while, but people don't really take advantage of it, and the Senate Bill 458 is kind of designed to allow it to be utilized a bit more commonly. And the expedited process is what it sounds like. It expedites the process that we might use for other land divisions. So we'd have a shorter 21-day completeness review instead of 30 days as staff to determine if they've submitted all the materials. You know, we'd be required from the state level to notify neighbors within a 100-foot radius instead of the 300-foot radius that we might apply for other applications. There'd still be a 14-day public comment period. It would still be, you know, a minor development, but it would be a staff level decision, and there would be no hearing that could be possible for this type of application. So that's another thing I just wanted to really make clear, is that these can't be appealed. If they are appealed, they would not go to the DRC or City Council, at least through our current, you know, the way that we would appeal a land use decision currently. It would go to what they call a referee, an expedited land division referee that's appointed by council, and then if it makes it through that process, it would go to the Oregon Court of Appeals instead of LUBA. So it's just kind of a different process that is, you know, expedited. We have 63 days to make a decision on an application instead of 120 as staff, and as I mentioned, the appeal process and public hearing process is quite different. There would still be some similarities, though. So, you know, I guess with this expedited land division, it would be considered minor development. It would still require a pre-app conference, neighborhood meeting, mailed notice, and that 14-day public comment period. You know, essentially, the way that we currently utilize this expedited system is that applicants are given the choice to either opt in or out. So essentially, when we go through the pre-application conference, we say, do you want to opt out of the expedited land division track? Or I guess it would be, yeah, the expedited track currently. So, you know, that's kind of the process that we're proposing for this as well. So, you know, applicants would be given the choice to sort of opt out of this expedited process and use our typical minor development process, or they could use, you know, the faster version. You know, we would still retain our conditioning authority for these types of applications for public improvements, and we would also, you know, continue to apply those clear and objective mitigation standards that we were talking to these expedited land divisions. I think, again, the biggest difference is that we would have to use this other procedure that is kind of set in stone at the state level, that exists currently, that, you know, would just have to utilize a little bit more because they're expanding its applicability. And that should cover it. I know there are probably some more questions, though, so I'd be happy to talk more.
Yeah, Eric, can you hear me?
I can.
Oh, thank you. I wasn't sure. So we do have some questions. Vice Chair Pepe?
Yeah, Eric, would you mind putting up your presentation again there? Specifically on, I just want to get a better or more concrete on the minimum and maximums regarding, what's that?
Oh, I was just asking Iris to put up the presentation. Can Commissioner Pepe talk while we're looking at this? Oh, okay. I guess we can't have both at once, Commissioner Pepe. Sorry. I guess if you can switch it back, that'd be great.
But if we're narrowing down the area, say from 300 feet to 100 feet of notifying neighbors, is that the minimum standard or is that the maximum? Just as an example.
So it's a alternative process. So it's neither a minimum or a maximum. If you are an applicant and you want to use the expedited land division process available through the state, you would meet that requirement if you send it out to the 100-foot radius. So I guess it's a minimum, but if you want to think about it as a minimum, people usually, just kind of do the 100. But, yeah.
And that's the developer who's going to be sending that out, not the city, correct?
That is correct. Although we do send out some mailings for the developer. But.
Okay. Would that prevent, if the city were sending it out, would that prevent the city from sending it out to the current 300-foot radius?
It would not, no. So if the city sends it out, that's what we had mentioned in the staff report, that we would endeavor to keep our current, 300-foot radius requirements. But, it's not necessarily something that we can control all the time. Yeah.
That's what I thought I read in the report, but I, again, was just getting a little confused on, it sounded like it was now not that going to be that case. So thank you for clarifying.
Yeah, it's a bit confusing. It's, something that will exist out of the code, it's like its own thing and it will, and it has been for a while. It just has been underutilized. So, I think, just to sort of speak informally, our idea is not to sort of copy and paste the expedited land procedure into our own code, but to continue to sort of use this opt-out sort of process where we're not exactly encouraging people to do the expedited track, if that makes sense.
Okay, thank you.
Yeah, Eric?
Mr. Chair, Mr. Chair, if I may, sorry.
Sure,
And I think it's partly my error. When I'm looking at the code here, it says that in reviewing an application, in the statute rather, Senate Bill 458, in reviewing an application for middle housing, a city shall apply the procedures under the expedited land division. So those would be the procedures we would apply. There's no opt-in or out.
Well, I was just thinking if the city was the applicant, I guess we would. Well, okay. Well, the opting in is, if they decide to do an expedited land division, though, right?
That's the,
yeah.
shall apply.
Shall, yeah.
And the city does receive these expedited land division applications from time to time. And it's always a bit of a fire drill for everyone, including the applicant in some ways, because, there's 63 days. And I think that the conventional process that has a 120-day a requirement that a final decision and appeal periods are exhausted within 120 days from an application be deemed complete. That timeline will occasionally it'll be stretched out by request of the applicant because there's some issue or there's some standard that they are maybe not attaining, and so they'll ask for additional time to submit more information or revised plan. The 63-day expedited land of it, I don't think we can extend that. I don't think we do. So it's sort of a fire drill, and I think it's going to be demanding on everyone with middle housing when we get some of these land division requests. So anyway, we don't have any choice. We have to apply the state procedure when they opt into that.
Well, that's just a good point, though, to think about the amount of work that some of these proposals will require. This is a lot more work for the review of building permits than we do currently for ministerial applications, or it would be at least an additional layer. Maybe that's the easiest way to explain it. So there's implications with some of these changes. Some of them are seemingly straightforward, but when you sort of translate them into our development code and processes, there are complications. So we're trying to take the path that we think has the fewest complications, but we would certainly welcome your input on, if we're getting anything wrong or if we're heading in the right direction or not.
Commissioner Phillips, you had a question?
Yes. Listen, I understand that expedited means you may have to change some numbers, and I don't think developers, they'll work with 21 or 30, whatever, 100 feet or 300 feet, but the one that I'm a little confused by is no appeal. That no appeal process doesn't set well with most people. Okay, so I'm a little.
Well, there is the appeal. It's just a different type of appeal in that normally we'd have appeal to the Development Review Commission to review the planning staff's decision, but this is a review from the planning staff to the referee. The referee then makes a review of that decision, determine whether or not it's correct. From there, the appeal of the referee's decision would be the Oregon Court of Appeals. In the normal process, you end up with Development Review Commission, City Council, LUBA, Oregon Court of Appeals, Oregon Supreme Court. So it does cut out the local process, if you will, the DRC and the City Council. The hearing or the referee is appointed by the City Council to review the.
Okay, that makes sense to me then. Thank you. I didn't understand that.
Yeah, and again, this is sort of the state process, so we're trying to comply with the state process, but we didn't develop it.
Eric, two questions. First is when we use the term referee, in other planning discussions, we've discussed hearing officers. Is a hearing officer and a referee synonymous?
I think the difference is that the state defined this as an ELD referee, so we're kind of down to the state's definition.
I would say the difference is that under the statute, the referee has the discretion of, the referee has the discretion of deciding what type of process they want to use for purposes of review of the decision. That can include written material only. I mean, if interested parties would submit their argument, because all the evidence is in the record. Okay, so the question is, how is the referee going to receive the argument by the parties as to whether or not the application meets the criteria? It can be by written material only. The referee could say that I want to have in-person testimony, just like a standard DRC type of a review thing. So a hearings officer, I think typically does receive in-person testimony and new evidence. The referee does not receive new evidence, and they have to decide whether they want us to receive it in written or in person.
Thank you. The second question was, when we start discussing about the restrictions on further subdivision of the lots, this may be a basic question, I may be missing something, but how would the average, owner know their kind of lot status? Would this in effect create a new zone, like a multi-family or a middle housing zone? And so that that then if your lot is in the middle housing zone, then it has these restrictions such as you can no longer further subdivide or partition? So my question is it going to be like a new zone called middle housing zone to distinguish when these have occurred?
No, it would just be a notation in the plats. So when you go to record the plat for the subdivision or land division, whatever type it is, there would be a notation in the plat, similar to how we have other notations for those approvals.
It might be a covenant too.
Yeah, maybe it's technically a deed or something too.
Yeah, the county surveyors and the land division statutes has specific requirements and limitations as to what can be put on the plat, what can be annotated on the plat. So there used to be a lot of land use conditions that would appear on a plat, like size on a limitation on the size of a structure or a special setback that would apply that was imposed through the land division process. And they said, we're not doing that anymore. These plats are really only for recording of lots and easements and not this other. So we don't obviously have any experience with this yet in terms of Senate Bill 458, so it remains to be seen what.
And, yeah, and I would just add, it's not a zone, it's a parcel. It's a parcel restriction. And how does the property owner know it? There could be a recorded covenant, but I think probably the most evident way is the building is on there. I mean, the developer built it for purposes of middle housing, and that's what it's going to be, that's what its use is limited as. And if an application were submitted, we would say it has to be middle housing, and it has to be the type of middle housing is approved for, so.
It'd be similar to a, existing, deed restriction on a property that you'd have to sort of be aware of if you're doing development.
Mostly abandon the
All right, thank you.
duplex, consolidate the duplex, and try to divide.
They'd have to terminate the middle housing, yeah.
Commissioner Buchanan?
Thank you. This is just a simple comment. I noticed in the paperwork it referred to the primary parent or master, which is oftentimes considered a term of discrimination. And something, since you're going through this code, it might be nice to omit that at this point rather than have to deal with that in the future.
Thank you.
If I may, Chair Heap.
Sure.
So what happens when, the building's no longer on one of these, middle housing sublots? The duplex is gone. What happens? You can only build a duplex on those two lots, but they're owned by different people, and you can't further develop them. Or, one person wants to tear down half the duplex. How does that work?
Yeah, I mean, it would be similar to like the way that an apartment complex is owned. Folks own their units in the apartment complex. There are similar, common areas that are shared, parking areas, open space that's shared. So if you're going to do anything that's going to impact other property owners that you're adjacent to, you're not probably going to be able to do that without their permission. But essentially we would be essentially codifying, or at least in a deed or some type of document, whether it be on the plat or in a covenant, codifying that this was a middle housing land division. You'd essentially be limited again to one unit per lot. Theoretically, you could, I guess, develop other types of middle housing on that lot, but if you're talking about a duplex, let's say just a duplex, you divide the lot in half, right? So there's one half of duplex on the other side, one unit on each lot. Theoretically, you would have rights to, depending on how you do the easement, but you would have the right to demolish and reconstruct a unit on that lot, but you couldn't demolish and reconstruct more than one unit on that lot. You don't have to comply with the parent lot.
Part of the whole point of it is to get rid of some of the parts of condominia that essentially regulate that process and make it like you said, so someone can't tear down one unit, etc. But a lot of that's cleared away in this more efficient system.
Yeah, they would be able to have development rights and full control over their individual lots, but when you have an attached structure, obviously there's implications on the other property, I suppose. But yeah, that's if they did want to go through and demolish it, that would theoretically be possible, I suppose.
But so these would in the title essentially say you're limited to a kind of attached housing.
Yeah, it would sort of solidify the type of middle housing. So obviously cottage clusters are going to have very different regulations than some other type of housing, townhouses as well. So yeah, it will also solidify sort of into perpetuity in some ways the type of middle housing on that site. But you could theoretically think of different permutations of that would still meet the parent lot, if you will, regulations. So I guess you'd still have to meet the regulations on that parent lot regardless of what you do to the smaller middle housing lots.
So there couldn't be something like, say there's a townhouse development and 50 years in the future, someone's able to, there are 8 townhouses, 8 lots, someone buys up 4 contiguous lots, that couldn't be, reconverted back into an unrestricted single lot.
No, again, it would be in the covenant or plat or whatever restriction that is recorded along with the land division. And, because it's an Senate Bill 458 expedited middle housing land division, it has different restrictions that apply.
Thank you.
Yeah.
So should we call them original lot and middle housing lots?
Yeah. Is parent offensive? What's a good
No,
term?
I'm serious.
Yeah, no, I am too.
Yeah, we'll think about it. So if you,
I just wanted, when you say they never shall be, I'm a little nervous about saying never in perpetuity. That's a long time. Will there be a process by which a person could acquire, say, four of the lots, and instead of having an 8-unit thing, turn it into 2 4s? It's possible.
Yeah, they would have to re-record the covenant.
Right, I mean,
That would be nice.
basically, yeah, you would have to abandon that plan and replat it, if we want to think of that thing, and then replat it as a different type of middle housing unit. The city has an interest in making sure that the development is, as we develop our standards, is complementary to the other properties around it. And if you went and take the worst example, I suppose, if you had 8 townhouses and you decided to put 8 single-family dwellings with the setbacks on it, you'd end up with tiny little houses, which is not the streetscape you're looking for. So the standards were developed for type of middle housing that's consistent with the neighborhood scheme. So I don't think you can just willy-nilly do that. Now, but I don't want to say never, because I think we have cases now where a property owner wishes to have 2 lots and they want to consolidate them together into one, and so, look,
Yeah, that's what I was gonna say. It seems like the purpose is that they don't want you further subdividing, but it seems like if you want to do like a lot consolidation in the future, that doesn't seem like that'd be an issue, because that's going the other way, right?
I think that's a good way to put it. You can't further subdivide, but you could merge, back and then reconfigure, I suppose. But you'd have to go through the process of replatting, re-recording deeds and things. All right, so my presentation is over. I would be happy to answer more questions, but yeah, just let me know if you have any direction or other questions.
Commissioners, any questions for staff? So staff can correct me if I'm wrong here, but I think, again, what we're looking at tonight is, what staff has outlined. Are we as a commission giving feedback to staff that, this is something that we would want to see presented in terms of a public hearing to come forth in a public hearing, or there are different options or different views that we'd like to be brought forth in a public hearing? Commissioners, any comments? None. So I think then commission staying what staff has presented tonight, the commission finds is sufficient to go forward to a public hearing.
All right, thank you, Chair Heap. Was that formed as a question, or was that more of a?
No, I think it was a comment of it, just and looking for commissioners if they want to give any feedback or disagreement. But I think the commission tonight finds that what staff has proposed is sufficient for a public hearing, so we're good with it as a commission.
Yes.
Great. I think I have some clear direction. Thank you.
Thank you. All right, and I'll do one final check. We did have it open for public comment, but there was nobody that wished to make public comment. That still remains the case. There's nobody wishing to make public comment, Iris?
That's correct. We had no one come in.
All right, so then we'll close the public comment on this, and we'll close on this agenda item. Thanks to staff, thanks to Eric for presenting. Thank you. Next, I think we'd like to move on to the next item on our agenda. Sorry, let me go back and I'll find this here. or just reopening. Next on our agenda is item number 9. This is other business. I didn't have any other business. Director Siegel, is there any other business that you would like to bring?
None from staff, thank you.
Right. And then we'll move on to item number 10. This is a schedule review. Director Siegel, would you like to give us a schedule review?
Yeah, thank you, Chair Heap and members of the Planning Commission. Your next meeting is on February 28th. I did want to note, however, the City Council's meeting tomorrow, or the 15th, to discuss middle housing. So there'll be Mr. Olson and staff will be presenting the work to date. So the work that the Planning Commission has produced, or the direction that you provided on the work to date. It's really just a final check-in with the council before, we issue a public hearing draft of the amendments, and the hearings process begins in April. There are some next steps, however, on a related task. So as you may recall, when the Middle Housing Code Advisory Committee worked through all of these questions about middle housing, one of the concepts that they were wanting to explore and that they had recommended to council, and in fact the council supported their recommendation, that we look at the definition of residential demolition for purposes of middle housing specifically, and the relationship between how demolitions are defined and where non-conforming development occurs, and really the requirement or the trigger for bringing non-conforming development into conformance with the code. So, these three concepts are all interrelated, and the Middle Housing Committee, I think, was really astute in picking up on that and considering, well, what can we do, given that there are quite a few properties in the city that are non-conforming in some respect, either to setbacks or lot coverage or even lot size. And the middle housing rules and the work and the body of work that you've developed address that on some level. I think you've addressed the lot size question, and the middle housing rules also kind of guide us on what we can do with lot size. But for those properties that have existing development on them, and they may be conducive to remodeling or an internal conversion to create middle housing, there's really a key policy or a number of key policy questions there in terms of what to do where that existing development is non-conforming to the development code in some respect. And the middle housing rules do give us some latitude in how we approach that. So we would like to discuss that with the Planning Commission on the 28th. I've pulled together a work group. Fortunately, we were very fortunate that the chair of the Middle Housing Code Advisory Committee, Randy Arthur, who serves on the DRC, and one of the other committee members, Carol Oker, who chairs the First Edition Neighborhood, and a local builder, someone with a lot of experience with middle housing and new development, Rob Matthews, all volunteered. And so we've been meeting this month. We've had a couple of meetings along with staff. It's been a very collaborative process, and so we've developed some concepts that we'd like to bring to the commission for your input on the 28th. So that, I realize that's new, so this is a little bit more than a schedule update that I'm giving you, but I wanted you to have some context for what we'll be bringing to you on the 28th for your input. And the goal is to have that, any code amendments that are prepared for this, to have those run on a parallel track with the middle housing code amendments, so that those would come before the Planning Commission for public hearing in April and would go on to the council. One nuance to that is that the demolition regulations they're not land use regulations, they're within the building code. And there's also a demolition tax that's in our tax section of the code. And so, typically that's not something that would come before the Planning Commission, but because the definition of demolition is really interrelated with this question of non-conforming development, we're going to try to brief you on both and have you provide some input on that sort of that non-conforming development aspect of what I've been describing. So it's fairly technical, but I think it's really impactful. Whichever way you decide to go with this, or that the council decides to go, it could make a real significant difference in terms of how properties are either allowed to continue to exist with these nonconformities, or as they remodel and they're added onto, will they be required to come into conformance with our code? So looking forward to that discussion on the 28th. And then on the 14th of March, Chair Heap, we had targeted that as I think a time to just do an update on the Planning Commission goals and work program, and then also discuss the City Council goal setting at that point to see if there's any adjustment that you would want to make to your work program. I think some of the topics that are going to be really timely there will be the next phase of our work in terms of House Bill 2003, which is the housing needs analysis, beginning to kind of schedule that work for the latter half of this year. And then, as you heard from Councilor Mans, there was also some discussion at the council's goal setting about maybe some pre-planning or very early preliminary planning for Foothills, although we don't have any direction on that at this point, but it's just something that we're tracking along with economic development. So hoping that we can discuss sort of all of that at a very high level, just in terms of scheduling and forecasting more than anything for the Planning Commission over the next 2 years when we meet on the 14th. So beyond that, we're still expecting, we're hoping to have a work session with the Lake Grove Business Association and neighborhoods that have been working on the potential update to the building design standards on that part of the town on the second half of March, or the second meeting in March. So I think that concludes the schedule update, and you've got a lot on your agenda for the next 3 months, and middle housing is going to be front and center. So we really appreciate all of your hard work on this. I know Eric and all of the staff have been working on it. We're really grateful for the effort that you've put in on this. So thank you.
Well, Director Siegel, one question back to our next meeting and the discussion we'll have on the definition of a demolition. I assume we'll have public comments will be accepted, and I'm just wondering, again, is this going to be initial discussion, or should there be more outreach potentially to let any interested organizations, neighborhoods, or parties know that this discussion is coming to the Plan Commission? It just seems like it has a potential maybe for receiving a lot of input. So I'm just wondering if, first to confirm we'll have public comments, and then is there any, directed outreach that we should be doing?
Well, that's certainly something that the commission can weigh in on, and give us some input on how you'd like to see that proceed. I can tell you though, it's very similar to the work that we've been doing for House Bill 2001. It's on the same timeline as that, and so sure. I think the expectation from council is that we will be bringing forward some code amendments that are really targeted to the potential for demolitions ahead of middle housing development, or how remodels and conversions of existing homes will work with middle housing. And so I think that's really the focus in terms of outreach. The folks who have been helping us with this in the work group, I think that would be a good question for them too, because they're each representing different constituencies. And in terms of the middle housing committee, there was certainly input at that level as well. So one thing, when we heard from the council during their goal setting about demolitions, and they did discuss this, and they're going to receive a briefing on this March 17th. And so one of the things that we made sure was, we conveyed was that the scope is fairly limited on this, and that we're not looking at the procedures for demolition necessarily, or the demolition tax is not within the scope of this. And I kind of what I heard from the council is that there may be an appetite to look at the broader scope of demolition and deconstruction and sustainability, but as a subsequent phase of our work. So I think that's how we're approaching it, unless we hear otherwise. That's kind of our approach in terms of process and public engagement.
All right, thanks, Director Siegel. Commissioners, any other questions on the schedule? None? Right. So thank you everyone for joining tonight. Happy Valentine's Day to everybody. Meeting's adjourned. Thank you.
Thank you, everybody. Have a great night.
Bye.